What's going on, everybody? TRAE4JUSTICE back in the building, coming at you guys with day 13 of the Daryl Brooks trial. I think we're on day 13, right? And I'm hitting the microphone. I'm already rusty right now. So if you all saw my last community post, I had to step away to take care of a few personal issues, and it's nothing that anyone should be concerned about. It's just something that definitely needed my attention in that moment, and now I'm back. But I'm sorry again for not updating you guys. It's just that I don't like bringing personal issues to the channel, because I like for this to be a place where everybody can just kind of decompress, I guess, because I understand we all have things that we're dealing with in life, and a lot of times we look at our favorite videos, or we just look at videos to not think about those types of things. So I don't want to bring that kind of stuff here, because I like for this to be that kind of environment for us all to just like come together and watch Daryl absolutely fail at not going to prison. But I want to say thank you all so much for all the nice comments, and I'm sorry for the people that were concerned, because I do see those asking if I'm doing okay, and I'm doing fine. I appreciate all of that stuff, and I'm sorry for making you guys worry. Okay, so on to the video. So in this one, they spend most of their time just reviewing documents for the jury, I believe, and it is absolutely hilarious simply because Daryl spends a majority of the time hiding behind boxes. I could not stop laughing, and if it's annoying during the video, I'm sorry about that, because I definitely laughed. I can't even count how many times. So I don't want to hold you all up, but I do want to say thank you to a few people that donated before we get started. Thank you so much to Letitia for a $5 donation. I really do appreciate it, and thank you for continuing to watch along. Thank you so much to Ms. Kimmy for a $10 donation. I really do appreciate it, and thank you for continuing to watch along and for sticking with me as well. Thank you so much to Laura Kaiser for a $5 donation. I really appreciate it, and thank you for continuing to watch along and for sticking with me. Thank you so much to Joan Coles for a $10 donation. I really appreciate it, and thank you for continuing to watch along and for sticking with me as well. Thank you to Budgie Girl for a £2 donation. I really appreciate it. I hope I'm saying that correctly. I think I say this at the beginning of every video, but I hope I'm saying the name of the currency correctly. But thank you so much for a £2 donation. I really do appreciate it, and thank you for continuing to watch along and for sticking with me. Thank you so much to Sonia Kimmer for a $5 donation. I'm sorry if I'm not saying your name properly, but thank you so much for the donation. I really do appreciate it, and thank you for continuing to watch along and for sticking with me. Thank you to Minnie T for a $5 buy me a coffee donation. I really appreciate it, and thank you for continuing to watch along and for sticking with me as well. Thank you so much to Mary for a $25 buy me a coffee donation. I really appreciate it, and thank you for continuing to watch along and for sticking with me. And last but not least, thank you so much to Ty Tyler for another $5 buy me a coffee donation. I really do appreciate it, and thank you for continuing to watch along and for sticking with me as well. But as always, I just want to mention, nobody has to send me a single thing. What I will say is, if you would like to donate to the actual victims and the community of Waukesha, there are links pinned at the top of the comment section. So if anybody is looking for resources to do that, it is right there for you. Okay, I really hope this is a quick intro, because I don't like dragging these out. So I hope you all enjoy the video. Thank you.
Wisconsin versus Daryl Brooks, case number 21 CF 1848. May I have the appearance?
All right.
Morning, Judge Sue Upper, Leslie Basie, and Zach Woodshell appearing for the state of Wisconsin.
Here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter, and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and make a reservation of all my rights here this morning.
Did he add more to it?
All right, good morning to you as well.
I don't remember him saying that much.
Individual known to this court as Daryl Brooks is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
And for the record, I don't consent to being called that name.
It is noted. All right, Mr. Brooks, just preliminarily, do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called that name. And what was the question?
Do you anticipate calling any witnesses today?
I don't believe today.
It's a pretty simple question.
Well, we are here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
Here we go.
Let me look.
He immediately pivots to ICFs because things are moving a little too fast for his comfort. He's
Actually,
not.
I just went to you and then went to the prosecution.
And thank you to whoever.
It is.
Hold on.
The audio's on.
And thank you to whoever left a comment about this. Someone said that this is a common tactic that sovereign citizens use. They try to like drown the court
Do you know when you sent those?
in ICFs and documents and documentation just to make things as messy as
That
possible.
would have been the 22nd.
State receive anything through like the inter-office communication?
We have not, I just checked this morning to see if there's anything new. Nothing has been received at my office.
Which means it's time for a tantrum.
And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state,
No objection?
from you, sir.
No objection. I definitely want those documents received as they obtain important information.
You said you forwarded them to a staff member on Saturday.
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
And those are 2 ICF forms?
Yep, one addressed to you directly and one addressed to the district attorney's office.
You know, he's so like sneaky, or just he tries to play so many games that I guarantee you he sent the email and put in like the wrong recipient or something like that. Like, I don't know. And he's gonna try to use that as like a way to say, oh, you didn't give me the right email address, or I don't know if that makes sense. At this point, guessing all the weird angles he's gonna
I'm sending that.
use is
I will
pointless.
send it with high importance, and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information make enough of proof for me, sir?
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz. Question was asked of, did he know if there were any recalls on that vehicle? And I believe that a Brady claim should be visited because there were in fact recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where Ford company were sued because of this, and those vehicles models from the year 2008 through 2010 were recalled, and that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained just by pulling it up, and you will see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to...
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles, and
he's not the one on trial.
in light of the fact that these vehicles were recalled because of this malfunctioning throttle body for I believe it's counts 1 through 73 to be dismissed.
Okay. Oh, I think maybe he's referring to the person that actually did inspected the actual components of the vehicle, because at one point they brought up I think he's considered a member of law enforcement that actually inspects parts of the vehicle to basically determine if what Darrell, one of his many arguments is that the SUV malfunctioned. So I guess now he's back to leaning in that direction, that being his argument. Somebody actually left a comment asking, like, is that his main argument? He's had so many at this point. I really can't list them all. Really, people in the comment section, they remind me of him all the time because he's gone in so many different directions with this. I don't know what his main argument really is. I mean, it's pretty safe to assume it's nothing he can argue. He just did this in a fit of rage, so.
All right, what's the response from the state defendant?
Thank you, Your Honor. As Trooper Schultz testified during his examination, consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper or Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here.
Right.
Further, Inspector Schultz would testify that that does not prevent the brake from working. So if this had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake, it would have stopped the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit. Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway Traffic and Safety Administration. There are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls.
Well, there you
it's
go.
a mood issue.
I don't believe it's a moot issue, and I actually have. The report should be in the mailroom as we speak. I had everything sent over priority mail. The actual information about the class action lawsuit, the actual information about the recalls for those models, like I said, 2008 through 2010. Now, in all fairness, Your Honor.
Okay, so I think before I thought he sent it through an email, so he's saying that he mailed it, but I guarantee you he actually didn't mail it. Like, this is some kind of tactic right now, just so he can say they didn't mail it off in time, and this would have been evidence that I could have used to actually show that my SUV did malfunction that day. So he's just trying to play at another angle here, hoping that it'll lead to some sort of mistrial. I'm guessing, like, oh, the evidence didn't come in time, and I sent it off, but it was like an error with the mailing system or something, or people were too slow or something like that. Like, he's trying to basically make it seem as if it's the court's fault that this evidence wasn't received right now. So, okay, I get it.
That's why I was asking for a Brady claim.
I knew it had to be something.
Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing this a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit if these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question, it was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action, because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because, again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head. I gotta
Also, he did email it.
Flip it. So give me a second.
Okay.
It's so weird that he will.
Just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm going to turn, because it's the only way I can read it. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled. no later than Wednesday, I just learned of some information that is extremely vital. I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that.
Okay, sorry to cut her off, but it's weird that he would wait this long to actually pull that out, like that information out. If he felt like that was an actual argument that he could have used at that point, why would you wait this long? Like, his idea of how he can muddy the waters here, and that's just like, that's how it's gonna work. He waits to pull out this information until after the witness is already left and they have dismissed the witness, and now he's pulling this information out to say, oh, okay, I know something now. But I can't remember how long ago the actual vehicle inspection part like happened. I feel like it was maybe 3 days ago at this point. So I have no idea why he went back that far. Like, you think he would focus more on the witnesses that he has left to make some kind of magic happen with that, which is impossible. We're on day 13. But yeah, it's just weird that he waited this long to do a simple Google search and find that information and like bring it here, which like it carries no weight anyway.
Would have impacted the mechanical function during the incident in question. I'll accept the state's offer of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request
There's
to
a tantrum
dismiss the
coming.
case, and I'll deny the request to recall this witness. Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him, and it was asking questions directly related to information contained in that report.
All right, go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So I
understand that, sir, but your request is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record. Either through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to?
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and I'm
telling
going to
you
trust.
she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like a.
So that's my decision.
I object to that, Your Honor.
I understand.
I
I've made my
object to that.
decision. I expect that you respect the decision, at least
No.
as we're not going to debate it further.
Yes.
I now have the
It needs to be-
ICF,
it
the
needs to
one
be
for the state to be
addressed, Your
provided
Honor.
for the state. Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, you need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Here we
The
go.
request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I
For
can't
the record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
That request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact,
What,
Your Honor?
any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion. So it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion
Here we
for
go.
finding the fact.
Denied.
Under what law and fact?
I
Your
made
Honor?
an oral ruling, sir. There's no requirement I do so in writing.
He's
So you're
thinking.
denying a legal. You're denying a motion for finding the fact.
I am.
So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to,
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and I'd
seem
ask
like
that
you're.
you
I
stop
don't need
interrupting
your
me.
advice.
No, I have to give you advisements, sir, regarding
I
your
need
right
you
to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's
Let's get him
failing
kicked
to
out.
respect the court's oral rulings here today. It's something that he's done repeatedly throughout this trial. Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't need
Do you
to
have
go
a
through-
witness to call,
You don't need to go
sir?
through anything with me on record. You
Actually,
need
I
to,
do so,
Actually,
sir.
you
That is
don't.
required by law.
Actually, you don't. You need to do your job as a public servant.
Mr. Brooks,
and honor the oath that you
I
took,
need to
Your
go through
Honor.
these advisements, and if you're going to keep interrupting
kick
me,
him
you
out.
will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed
contempt
to
again.
the next courtroom so that I can properly go through these advisements without being interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I need
due
you
respect,
to
in Illinois
not
versus
interrupt
Allen,
me. This is another interruption.
In Illinois versus Allen.
Mr. Brooks, I'm not going to have a debate with you on the meaning of Illinois versus Allen.
I'm not trying to have a debate.
You are advised that it continued.
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that I'm
I've said that multiple
goodness.
times. I've given you multiple.
Just kick him out. Here we go again. Very beginning of the day. He's staying true to his routine. This is his routine, and he is sticking to it to the very end. He's going to pull this same move at the beginning of every day. I'm not even, like, I'm sure at the beginning of day 15, which is where they bring family members up. I think it's day 15. Yeah, at day 15, where they bring up family members, he'll probably still try this tactic to just talk over her in the hopes of being kicked out. But I think he actually does stay in the courtroom on that day, from like some clips that I've seen.
Opportunities to stop interrupting me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding you
removing me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor,
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect,
He's not going to
Illinois
stop.
versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in
not true.
mild manner, tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
the standards
because
of
it
decorum and
doesn't.
civility, and one of the
Illinois doesn't.
bedrocks is that he
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to the next courtroom so that I can go through
It does
proper
not state-
advisements with him without being interrupted.
It does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there. Again, I'll
It
make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit
Thank you.
agreement for something that I.
All right. So there we go. Just Daryl sticking to his routine pretty much. I'll go ahead and fast forward though to they get him in the other courtroom. So 1 second.
Madam Clerk, might I please get verification that the audio and video are working in the neighboring courtroom? All right, thank you. I do have verification. There are headphones
He
on
throws
the
the
table in front
headphones.
of Mr. Brooks, should he choose to wear them. I see he's reading from a book at the moment. I do need to make a record that this morning, although Mr. Brooks was not raising his voice, there were repeated interruptions. He wanted to debate rulings that I made after the fact. Just this morning alone,
That was really creepy how he held up the
about
Bible just there.
26, 27 different times he interrupted me or spoke over me. Once I made a decision on his motion to dismiss and his request to recall a witness, he then asked if for written findings. I denied that. He then asked for what law I was following. I indicated I wouldn't explain that further, that I already made an oral ruling. He asked for a stay. He asked for dismissal. All of those things I either denied or said I wouldn't answer, specifically as it relates to the request for an interlocutory appeal, since I would not be the judge or court to which a request would be made. That is something that would be made to the Court of Appeals. And although I would have authority to grant a stay pending appeal, there is no appeal that's pending. I gave Mr. Brooks multiple opportunities to stop talking. I asked him repeatedly to stop interrupting me. I advised him that if he continued, he would forfeit his right to be present in this courtroom and would be taken to the neighboring courtroom. I believe I gave that warning at least twice. Of course, this comes on the record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct, forfeited his right to be present on a number of occasions due to his conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today, and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through, and I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to pledge that he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has passed, and he, at many times, has been able to conform his conduct. I would note during the vast majority of the testimony that was provided during the state's case, he was in the courtroom. If not during the entire time, he was able to cross-examine witnesses. We had a couple of issues during the testimony of witnesses he called, and of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute, though, and ask Mr. Brooks, because you did not answer the question previously, other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse, to call today? I need an answer to that question, sir.
We know he's not going to give that answer.
So we addressing subject matter jurisdiction that we haven't addressed when I was just over there, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction.
Exactly.
I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point his request to dismiss the case based on a lack of subject matter jurisdiction. Mr. Brooks, I will be asking you a couple of questions. I do need a response. I am unmuting you. Do you have any other witnesses other than yourself available at the courthouse to call this morning, meaning now?
This is the jurisdictional challenge right here. So are you going to address subject matter jurisdiction and prove it for the record or not?
So I've asked Mr. Brooks twice now whether he has any witnesses to call other than himself. He has declined to answer that question. Sir, if you fail to answer that question, I will interpret your failure to answer that as a no, and you will lose the opportunity, you will forfeit the opportunity to call any other witnesses on your behalf other than yourself. So I will ask you one last time, sir, do you have any other witnesses at the courthouse available to testify right now?
One more time. Don't even answer, Daryl.
I'm not getting a response at all.
Am I unmuted?
You've been unmuted, sir.
You just said I was muted, so I'm not sure. I don't know when you muted me or when
Well, me muting you doesn't affect you being able to hear the court because
Yes, it does.
that only
Yes, it does.
mutes your audio coming into this courtroom. I confirmed already
Why is my
that
audio muted to begin with?
that is simply a misstatement. I confirmed with the bailiffs that the audio and visual were working.
Why is my audio muted to begin with?
Because you interrupt the court repeatedly. So I'm going to ask you yet another way, even though for 3 times now he has failed to answer this court. You indicated last week that you would like to call your mom as a witness, Dawn Woods. You were provided with notice that the state would not be assisting with that in any way. You indicated when that was said that if you wanted your mom to testify, she would obey you and she would be here. So I trust that you've made arrangements for her to be here. Are you going to call Dawn Woods as a witness this morning and specifically now?
So magically he couldn't hear again.
I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted though, for a while now. We can obviously hear him. I will ask Mr. Brooks a third time. For the record, he's finally putting on the headphones. Is Dawn Woods
Did he just put his middle finger up? Was I the only one that saw that? Look, I don't do this too often. I'm going to back up a little bit. I'm so sick. It looked like he just put his middle finger up. So he's getting more and more volatile here, pretty much. Okay, maybe not. I don't even know what that was.
Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
No, let's just mute him. Let's carry on here.
For the record, Mr. Brooks only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Mr. Brooks's statements that the audio doesn't work when I mute him is simply false.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir.
You are lying on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses, other than perhaps himself. I then specifically asked him about Dawn Woods because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this
you
case.
Absolute clown. You.
I would
He stared at the Bible.
Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. when considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses.
He really is just staring at it and not reading it at all. But only Daryl would use a Bible as a tool to hide his face. Like, that is the weirdest thing right there. I thought for a second he was going to do the thing where he pulls the boxes over in front of himself, because I think that's coming up at some point. I don't know if he's done that yet, or he might have done it earlier on. Yeah, I'm not sure. I'm getting it all mixed up, but that's absolutely disgusting.
To go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that.
Here we go again.
I ask Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
Mr. Brooks, you're unmuted.
He's unmuted.
You're unmuted. Just speak directly to you. I'm here. Can you hear us?
I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear.
And you know something? I'm pretty sure he's trying to break those headphones.
Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin, 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him, although I haven't seen it. If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that? No response by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that?
His eyes are moving now.
Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education.
That's hard to believe.
Of course, at the Waukesha County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication within the last 24 hours, or any drugs or any alcohol? I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you going to verify it on record?
So he did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours.
And he responded to her, so he can hear.
I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, "What did you say?" Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
You saying. So if you can hear me, I don't hear everything you saying, and you know I don't hear everything you saying. So cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
So
Mr. Brooks, have you made...
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate it if you would make the record clear and correct.
This is a literal clown show. He's responding to her right now, and he's even mentioning stuff that she had said while he was pretending like he couldn't hear. And he can't understand. Oh my gosh, man. This is an absolute clown show right now. Like, he's getting more... I don't know what to call this. It's getting more ridiculous, though, as time goes on, because it's not even really... It's not even something that he could maybe say this possible, like, I couldn't hear her. How are you responding to her right now? And things that she said, I'm sure she's going to bring that up here in a second.
Clearly, he heard me say that for him to make that distinguishing
I'm
statement.
sitting right
Exactly.
Don't you see me looking all up to the microphone so you can hear me?
I don't have an issue hearing you at all, sir.
Can you hear me when I'm right here?
I can. Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom. Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
Now, have you made a decision to tell
I will ask you again, sir. Have you made a decision to testify in this case?
To address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim?
What?
I'm going to mute him for the moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction. He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no and that he is not going to testify. So once again, I am unmuting
He's really
him.
going to scream now.
Sir, have you made a decision on whether to testify in this case?
Oh, wait, he's back to pretending like he can't hear, so never mind.
There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to...
How long have I been unmuted?
Sir, do you want to testify in this
You
case?
was muting me when I had the headphones on just a minute ago. You just said you was muting me. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do
ain't
you
asking
want
me
to...
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for me.
answer. I'm going to
You
move
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court.
And you know he thinks he's being so clever about this. Like, I know in his mind he thinks he's dressing this up to really appear as if he can't hear, and that whenever he tries to do an appeal or whatever, that it's actually going to work in some way. When he's, at times he can hear, but then he can't, but then he has such a temper that he still responds to what she's saying. And I love that she's taking like little jabs at him about the fact that I haven't seen a page turn yet, but yet he's staring at a book. I feel like, and I don't know if this is true or like this is something she's doing. I feel like she's doing that on purpose in a way to make him respond to her because he's so easily aggravated or agitated. Like, whatever she says, he feels like he has to say something back. But lastly, I feel like he's trying to break those headphones. Like, when you see how aggressively he grabs them, it looks as if he's just trying to break them, so maybe if they look at them, he can say that he really can't hear, but he puts them on and he can hear. I don't know. It just looks like he's trying to break them, though. But it might just be him
This court,
being a baby.
as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the question in the affirmative, I will interpret his failure to respond as a no and that he is not going to testify. So once again, I am unmuting him.
He should not get any more chances.
Sir,
after all this stuff.
Have you made
Like,
a
he really.
decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to...
How long have I been unmuted?
Sir, do you want to testify in this case?
You was muting me when I had the headphones on just a minute ago. You just said you was muting me. So when
You see how instead of answering the question, he just immediately goes to trying to like swarm her with a bunch of different questions that he just wants to ask to distract her from whatever. Like, it's not even set up in a clever way. And when he's free amongst society, this is pretty much how he tries to get everything done. He just manipulates in this way by drowning someone in questions and words and just making them confused to the point where they're just like, dude, okay, whatever you want, just here. Just get away from me.
have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do
ain't
you
asking
want
me
to...
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for
answer.
me.
I'm going to mute him again. Again, it is very clear to this court that
Exactly.
he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court. This court,
It's ridiculous.
as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court
Nice.
must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom, because this morning alone he is yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings.
Okay. I was just going to say really quick, isn't it interesting how that's like his go-to thing whenever he gets put in the other courtroom is to just open up the Bible. I guess it's just so it looks as if like, oh, he must be a good guy. He's reading a Bible, right? Like in his spare time. And by spare time, it's him being kicked out of the main courtroom. But isn't it funny how now he's reading documents when like you would think that's what he would be doing this entire time, given the fact that he doesn't read them when he's in his jail cell. So why does he never take the time? I mean, it's a pretty stupid thing for me to point out right now, but it's just weird that that's now he's finally opening up a folder and he's reading something, which he's not really reading it. He's still trying to make it look as if he's being productive in some way. Like everything he does is completely, it's all fake.
Court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify. I am unmuting him.
Why is he
and
getting
will
another
attempt to go through
chance?
this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct. I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks, do you understand
What an absolute
and are aware
clown of
that
a
you have a
human being.
constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware. So why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right to testify, and that if you choose to testify, that you would be subject to cross-examination by the state. Did you hear me say that?
I didn't hear you say anything. I don't understand what you're asking.
You
He is
responded.
willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify.
Your Honor, with all respect, you've been trying.
Did you hear me say that?
answer questions for, I didn't hear you ask me anything. And I
Sir?
don't understand.
He's
Stop
responding.
talking and I'll ask it again. Sir,
Can you ask me to stop talking?
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do
I
this
got the
one last
headphones on.
time.
You have to hear them. I got the headphones on.
All right, then let's...
Obviously, you can see that.
Once again, Mr. Brooks is being disrespectful. He is
That's not being
blurting out
disrespectful. I'm
information.
saying
He
the
reverts
fact.
back to subject matter jurisdiction. He
the
accuses
fact.
this court of not honoring its oath. He just accused me of practicing
haven't.
law without a license. Again,
You
all
haven't.
attempts
No, I said
to
practicing law
deflect
from the
away.
bench.
I'm
I
going
said
to mute him
practicing
once
law.
again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify, and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that or not. And based upon, pursuant to State versus Anthony, and looking at the balancing test that this court must consider,
What an absolute baby. He says, can you ask me to stop
this
talking?
court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated He has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence.
Okay, sorry to pause in the middle of that because she's explaining something really important, but the weird part about this, you heard how she described him. He's a stubbornly defiant individual, and understanding the type of person he is, he's probably so proud of himself to hear that that's how he's being described right now. Like, so apparently it's over 15 days. I know it says like trial day 13, but she says it's been over 15 days now. And during this time that they've gotten to know him, or during this time that we all have gotten to know him, we see now the type of individual that we're dealing with. And it's pretty safe to say he's probably very happy about that. If he didn't feel like that's something he should be proud of, he would stop. But we all know at this point he's not going to do that. But yeah.
Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The court in Anthony cited the U.S. Supreme Court from Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct. Whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court. That court went on to discuss waiver and forfeiture and ultimately went on to conclude the following. We now conclude that the right to testify may in appropriate cases be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility, and decorum, and balancing all of that against Mr. Brooks's right to testify. This court is not making an arbitrary decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this trial, and specifically today based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken as by this court really as no, meaning the specific question, have you made a decision? And as for all of those reasons, that this court will make a finding he has forfeited his right to testify.
Yes. Couldn't be happier to hear that. And there's actually a point I wanted to make, but I'm not going to pause here.
With that, then, there are no other witnesses to present for the defense. Before I bring the jury out, I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor. Thank you.
All right. I would like Mr. Brooks to be brought back over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledges.
Thank
Sir,
you. Okay, mute him.
You're trying to, you asked me a question, now I can't answer.
Yeah, no, go ahead, answer.
You're trying to coerce me into violating my right to remain silent. How can you coerce me into my right to remain silent? So you're not going to protect my constitutional rights? Because I didn't answer nothing that you was trying to ask me before when I had the headphones on, and you can't make a decision for me. You can't.
Look, at this point, after everything that she just put on the record, because she explained all of this right now, and of course he's pretending like he didn't hear it. But at this point, it's really no need to engage with him anymore. Like, you explained exactly what you're trying to do and why you're making the decisions that you're making to put him in the other courtroom. So at this point, she should really just mute him, keep him in there. I mean, he even said from his own mouth, I will not pledge to do anything. Okay, well, we don't need anything else from him, I feel like. But she's gonna, I know she's gonna bring him back in here. Like, I just know it, I can feel it. She always does, but I get it.
Constitutional rights.
Sir, if you'd like to testify, then you need to simply go through the colloquy with this court, which I've given you 3 opportunities to do, and you have decided not to.
No, you can't tell me what I decided to do, because I didn't decide to do or not do anything.
Are you willing to?
Your Honor, by law, you cannot coerce me.
I'm not coercing you, sir.
Well, you're making a decision for me based on something that I did not say myself.
Last Friday, I specifically directed your attention to State versus Anthony. I discussed very briefly at the end of the day on Friday the case law that is relevant on this topic, including State versus Anthony, Rock versus Arkansas, and Chambers versus Mississippi, to specifically put you on notice.
Did you recall what was going on Friday?
Mr. Brooks, I'm going to mute him again. I'm not going to have a debate.
What?
I've made a finding. I've given him yet another opportunity. If he's willing to go through the colloquy with the court, he wants to challenge me instead and saying he doesn't consent. His lack of consent to this entire procedure is noted for the record. Based on his inability to pledge to this court that he will honor that ruling and be respectful of the jury, I'm going to leave him in the other courtroom.
Yes.
The jury's going to be brought out, and he will remain muted, and I will simply advise them, as I have throughout this case, that he's appearing from another courtroom and that his appearance from the other courtroom should not in any way be held against him or influence their verdict in any way. I will tell them that there are no further witnesses for the defense, and then I'll ask the state if there is any rebuttal, and then the jury will be excused for the day, because we will have I anticipate will be a very lengthy discussion on jury instructions. Again, I will advise Mr. Brooks that if at any point in time he wants to come back over, he needs to advise the bailiffs, but it does need to be accompanied by a pledge that he will follow the rules of civility and decorum, and he will not specifically challenge the court's rulings regarding closing off of his ability to call witnesses or testify on his behalf. All right, let's have the jury brought out.
All right. You know he's about to say he wants to come back right now. Like, look at the way you can see it. He's freaking out right now because he can't see her on the stand. So they must. The only reason she would do that is to conspire against him, right? That's the only reason she would do this right now. I'm sure she's passing some sort of document to somebody that would actually lead to him being set free. Like, this is the way his mind works. Or that's what he tries to make it seem as if. He tries to make it seem as if that's what's happening. But those poor bailiffs, man. Whatever gibberish she's spitting out at him right now.
Thank you, everyone. Please be seated.
All right.
Ladies and gentlemen of the jury, at the moment, Mr. Brooks is appearing from another courtroom. This must not be held against him in any way and must not influence your verdict in any manner. At this time, I will advise the jury that the defense case is rested, and I'll ask the state whether there's any rebuttal evidence to present.
No rebuttal, Your Honor.
All right, then with that, I will declare the evidentiary phase of this trial concluded. I'm going to excuse the jury for the remainder of the day so that the parties and I go through all of the jury instructions, and I anticipate bringing you in tomorrow morning. Instructions may very well take most of the day. My hope is to then have the closing arguments and then have the case be turned over to the jurors. If not by tomorrow evening, sometime Wednesday morning or early afternoon. With that, I'll rise for the jury then. Please turn your notebooks into the civilian bailiffs. I'll give them back to you during deliberation.
It's always funny when she tells the jury not to pay attention to him being in the other courtroom. It's like, you know, they see this and they're wondering, or they know exactly why he's in there. But we are getting really close to the end of this. Like, the evidentiary phase is already over.
Thank you. Be seated. Before we begin, I will have Teresa print off what at least we do have for both parties. I'd like to take a short comfort break. I'll invite Mr. Brooks to come back over, and then we'll start with that jury instruction conference. We'll take about 10 minutes. Thank you, everyone. We are in recess.
All right. So I'll skip back over to where everybody's back in the courtroom.
On the record, appearances are as they were before. The record should reflect that Mr. Brooks continues to appear from the other courtroom. I would like to
Music
make
to
a
my
record
ears.
regarding the audio and visual from the other courtroom. I've asked that one of the bailiffs who was present during the last session, present in that courtroom, come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine, our IT specialist. He too will take the witness stand, and I just want to make a full record of, he did a decibel reading regarding the audio as well. All right, we have Deputy Kibler. If you could take the witness stand, please.
This seems so familiar. Didn't another deputy do this? Or another bailiff?
Sir, could you please raise your right hand? Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
It is.
Thank you. Please have a seat. Please state your first and last names for the record.
First name is Nicholas, last name is Kibler. First name Nicholas, last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And Did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
Very smart for them to put this on the record. And it also shows that he's completely lying about the hearing problem, because when he's in the courtroom with Judge Darrell and everyone else, he seems to not have a problem hearing. But now all of a sudden he's in the other courtroom and the volume is even louder there in the speakers, or from the speakers. And now magically he can't hear. Like, it's absolutely ridiculous. And he's look at how upset he is at the fact that they've just debunked all of this right now.
All right, that's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
And at
Good
any
question.
time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
No.
All right, thank you. You may step down. All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have, I have it up on my screen. Can you do a project it, please?
And now he puts the headphones on.
All right. There is, first of all, sir, stand and raise your right hand. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you. Be seated. State your first and last name for
Oh,
the
this is a
record,
new
please.
witness.
Zachary Tremaine, Zachary. Tremaine is Tremaine.
All right, and what is your position with the Clerk of Court's office here in Waukesha?
I'm the IT coordinator for the Waukesha County Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the DB meter later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control panel. So you push buttons on it and actions happen in the courtroom, AV related. At that time of the photo, my phone is registering 67.3 decibels in that courtroom, and that was when the judge or the court was talking, and then the sound was coming over the speakers in the other courtroom.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65. So it's louder than the audio feed going to the media right now.
All right, thank you. Any question from the state?
Sir, I'm looking at the photo, and Your Honor, for the record, this photo will be made a court exhibit?
Yes.
Okay. I'm looking
Nice.
at your phone screen, and it looks like in the upper right-hand corner, it appears the time is either 9:26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
Okay,
it is approximately 9:26 when the photo was taken.
okay. Those are my
Daryl's
questions.
probably going to scream about
Thank you,
that.
Mr.
I'm sorry.
Oh, go ahead.
Do you happen to know what the decibels are in this room?
I don't. I'd have to pull the same thing up on my phone while people are talking.
Okay, thank you.
Mr. Brooks, any questions for this witness?
For the record, I don't consent to being called that name.
Do you know anything about
Hearing problems?
the hearing when someone has
I knew
hearing
it.
loss in any of their ears?
I do not.
So it'd be fair to say you don't know if I can hear everything good from this courtroom.
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see what photo that everybody else is in there seeing that was supposed to be made an exhibit. I have not viewed that, so I don't know what's being referred to when you refer to the picture.
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that up momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up.
Okay, so this isn't a new witness. I thought for a second they just brought a new witness in, but this is the person that actually measured the decibels. They are thoroughly dismantling everything that he's saying right now. And it probably would be a good idea for them to measure the decibels in the courtroom too. Just to have like a side-by-side comparison, because he can hear them clearly, but in here for some reason he magically his hearing problems came back. So that was a really good question from DA Sue Opper. But while there's a break in the action, I just want to say thank you all so much for watching this with me once again. Hope you're all doing great all over the world, wherever you
I'll
are.
have to stop the polycom, Zach.
Yep, you have to hang up and then join into the Zoom meeting.
Okay, hold on, please. Can you do that? Stop the call from Polycom to Polycom, and then I'm going to call it in through the Zoom so I can share the screen with the exhibit, which will actually help when we do jury instructions. Copy that. Hang it up.
Okay. But yeah, I hope everybody's doing good. And thank you all for all the nice comments. Like,
Systems are out, so hold on.
whenever I take a good bit of time off like this, I don't even know what to say about it. It's like, even though I feel like I am resting from like watching this absolute man-child, but at the same time, like, I do miss you all, and it feels weird
All right,
taking
so
such a long break.
Record should reflect that I've now changed the audio visual from the Polycom unit to the use of Zoom. I've called in both courtrooms, and they can hear from over there, and then I'll do, I just need to get back on so I can get the email. Give me a second, I have to go from double screen to single screen the way I sign in, but that'll take me just a second, and then I'll share screen so the color exhibit can be viewed by the defendant.
Okay. He's still finding ways to like hold up the process even when he's not in the courtroom.
All right, now the court is sharing screen and the
All right.
image is being displayed.
He's going to say he can't see it.
You see it? Okay, thank you. Any
Okay.
questions regarding that then, sir?
I'm surprised he admitted it.
Pretty much already answered. You don't know if me myself can hear everything good in your courtroom, correct?
I do not, correct.
No further questions.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down. All right, I
He
just
didn't
wanted
even
to
need
put
to see
that
the
on the
image.
record since
To ask that.
that was an issue raised by Mr. Brooks previously. Now, I need to get a copy of the jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again, it's all the same, 107 pages, and then my written copy is on its way.
I accept the value, return the value each document. That's if I'm not muted.
You're not muted.
I also would like to, again, ask for subject matter jurisdiction to be proven on the record.
Your request is
It
denied.
has yet to be verified. It has yet to be verified.
He's not muted, but he's
Your
working
request
on
is
it.
noted.
Your Honor,
It's denied without further hearing or consideration.
I was just told that, the evidentiary phase is supposed to be closed. How come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence?
I knew he was going to do this.
I didn't rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record for evidence. How is that so, Your Honor?
So the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request. I
So
said,
you're saying that I have no right
He
to
found a new
present
angle to
evidence
argue.
and to have exhibits as the state's been able to do.
Here it is.
Mr. Brooks, I'm
Are you
not
denying
going to
me
have
my-
a debate about this
Are you
now.
denying
I
me-
have,
are you-
I gotta
are you
mute him
denying me
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony previously by refusing to answer the court's questions. I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that he, from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe without fail they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions.
Isn't it so much more
Mr.
peaceful?
Brooks wants to abide by the rules of decorum and civility.
You can just
I
mute
will
him.
unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback.
Here we go.
regarding jury instructions. It's typically a back and forth. We'll go through them, and I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that, and then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Muted.
All right, you're unmuted now, but but you have to not interrupt.
No, you can't, I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them. You filed everything that I gave to you.
Right, Mr. Brooks, I'm going to mute you because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice.
It's so weird. He feels like that's a punishment to her, the fact that he's taking the headphones off, which he can still hear her through the speaker system. But he doesn't realize he just voluntarily took those headphones off and handed them to a bailiff. So he can't then say, well, I couldn't hear you the whole time, so this was unfair, the fact that I couldn't hear you. And so if he couldn't hear her, which is stupid that I'm even still entertaining the idea that he can't. But just say if he couldn't hear, he just voluntarily took the headphones off. He's done it several times and tossed them onto the table. So he can't then say, well, I didn't hear her the whole time. Well, sir, you took them off. So whose fault is that? Attorney? Fisher Price attorney?
But
You can't say that
going
then.
to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment.
Nice.
I'll unmute him again, but you are advised, sir, you need to be proper, you need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions. So once again, I'll unmute him to see if he can follow these simple rules.
He's going to say something crazy.
You need to tell me why I can't present evidence. How can you deny me the fact? How can you deny me my right to present evidence?
All right, I will mute him once again because he wants to continue. And again, I understand he's upset. I understand that. But he has himself to blame for his conduct this morning and the rulings that I've made. All right, so let's go through these jury instructions. First of all, has the state received a copy of the draft?
Yes, Your Honor.
Thank you. Mr. Brooks, do you acknowledge receipt? I believe you
He
did.
already
I acknowledged
did,
it previously, but do you acknowledge receipt of the draft of the final jury instructions?
I didn't acknowledge nothing, and I don't acknowledge anything now. I have not received anything.
I would ask the bailiff to
I
pick
don't
up the
receive.
documents from the floor and put them in front of him.
And
once again.
I'm not presenting it to nothing I don't give my consent to. You can't deny me the right to put on a defense. How can you tell me when I just stated
I'm going to
3 or
read it
4
once
times?
again because, again, I understand he's upset. If the bailiff could confirm, well, he put him on top, he put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that.
Right.
The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture by conduct of his right to present further evidence on his behalf.
Yeah, but the outburst is so much
I know
more.
one of the things
Hold
I
on.
probably need to look at, I'm not sure if Madam Clerk did this or not, would be the language from the amendment
What is he
from
doing?
the amended information on count 70.
Oh, he's making his fort. It's time.
I changed. Hold on.
He's finally doing it.
76.
40 years old, everyone. Look at this.
It says near free
Hiding
press.
behind a fort of
That's just one
boxes
question I had.
at the age of 40.
So, state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far, though.
Okay. Fair enough, there's 107 pages. I certainly can give the parties some time to continue to read through them.
I put 325, 141, and 172 at the end because I wasn't sure.
The top of his head poking out from under the boxes. Him being in the other courtroom just makes him look way sillier. I mean, he looks silly all the time, but he just seems cartoonish. Like when he's in the other courtroom, he can do nothing. Like, at least when he's here, he can scream and it has an effect on the whole entire process. But in the other courtroom, she just mutes him.
Is requesting to go back to his cell at this point. I'm going to deny that request. He can remain in the other courtroom.
Nice. But yeah, this just makes him look way sillier at this point. He's peeking out from behind them.
I know he's muted, but I can certainly hear him.
You can
from
literally-
this side. He appears to be yelling at the top of his lungs. I can't decipher what he's yelling.
That is horrifying behavior. Like, you can hear him screaming from the other courtroom, and it just sounds like terrifying. It's to the point now where it's like, it's hard to even imagine that he was free, like just walking around, and this is the type of person he was. But look, I'm not going to try to continue thinking that deep into it. It's definitely scary stuff to imagine, though.
I'll advise Mr. Brooks, without a specific waiver of his right to be present,
sorry.
even if it's from the remote courtroom, he's going to remain in that courtroom. And that would require him to have a colloquy with me.
I'll definitely cut this part out, though, because they seem to just be going through some paperwork and looking through some documents right now. So I'll cut to when either they get a witness here or when Judge Darrell continues with... Hold on, he's still screaming. But yeah, I'll cut this part out.
Mr. Brooks, I know you are still muted by me, but I know the audio is working, but I would ask you to specifically advise if there are any specific jury instructions that you are asking be read to the jury.
The screaming from before still has me chuckling, but... Alright, let me calm down. Yeah, I should have known at this point he's not going to answer that question.
Mr. Brooks, if you have specific instructions or categories of instructions that you believe this court should consider, I need you to write them down on a piece of paper. If you don't have, I believe I see a writing utensil. I'm not sure if I see a pad of paper. We'll make sure you have that. But given your current demeanor, which is still seems quite animated, and a loud raised voice, I'd ask that you write it down.
Perfect. Isn't this symbolic for how he is as a person? He's hiding behind a stack of boxes. So he's hiding, but yet he's screaming at the top of his lungs like he's just the toughest guy in the room right now. But at the same time, he's hiding. Like, I feel like it's a perfect symbol of how, like, who he is on the inside, to be honest. But I don't know. I understand this isn't like a body language channel, so I don't want to get too deep into that kind of stuff, which I don't really know that much about that kind of stuff anyway. But
How's the state doing on its review?
107.
Okay.
dude, the fact that they're able to actually review all of these documents so quickly, I'd imagine they've seen these types of documents so often that they just know pretty much what they're about, so they don't have to look at certain parts of it. But the fact that she said they're already on page 107 and they're just kind of looking over that, like the very last page, it's incredible. He is so upset they're not showing him any attention anymore. Like, they're just looking over documents, not even paying him any attention, and he's still screaming, trying to get them to notice him. It's like when your parent is like working or something and you're a kid and you're tugging at their pants trying to get them to like look at you.
I just want to make a continuing record that Mr. Brooks is still, I can still hear him even though he's muted due to his level, his tone of voice and volume level that he is using from the neighboring courtroom.
Yeah, he's making himself look great for an appeal, right? The fact, because you know he's going to try to actually file for an appeal. But, which I'm so happy he's not going to, like, it's not going to go anywhere. But the fact that he's doing this and he still thinks, it's just the slimiest thing ever.
Why don't you go through and tell me what requests you have, starting, and then we'll go page by page and just tell me what page number and what section.
So I think the first concern I have is with regards to the bail jumping. I know that we had charged, there's two separate felony cases. The defendant was out on bail, and I do believe it would be assistive to the jury to have the specific case number. So when we first talking about 61 of 107, we start talking about the bail jumping, and then we go specifically on page 63 of 107, when we could talk about count 74 and 75, I think it might be helpful to put the Milwaukee case number, because they are different case numbers, so that they know exactly what they're finding, that he was out on bail and that as conditions
That's a good
of his
point.
release. And those bail bonds were entered into evidence.
But now we're going to have to ask Daryl about it.
Let me look at the,
And he's either going to sit quiet or just scream.
And then just, because I think this was just well, I guess I'll have you, when we look at the verdict forms on page 102 to 107 for the bail jumpings, there's verdicts for the bail jumpings for 3 separate counts, 74, 75, 76. I don't think there should not be one for 76. I believe that should be the battery.
that would be true. And then I'll ask Mr. Brooks if he has a position on that. Sometimes it's easy if we just list out, I guess, what the changes are requested. I'm going to
Sure.
make some notes and then we'll go through
Sure.
them one by one. But so,
And I don't
first is
believe it
page-
was spelled out in the amended information.
Say that again?
I don't believe it was spelled out in the amended information.
Right.
So that would be page 63 of 107, whether or not we want to put the specific case numbers.
I can tell you right now, I typically like to follow the information, so I'm probably not inclined to do that, and we can argue that though to the jury, but
Okay.
let's go through the list and then we'll get
Okay.
the defendant's responses if he would like to give us those, but we'll go through the whole list. So that's the bail jumping.
Yep, and then with the verdict forms with regard to the bail jumping, just to put on the record, page 102 of 107, I believe there's a count 76, which details it as a bail jumping. I believe that should be the battery.
All right.
I did notice on
Sorry. This is probably a dumb question, but these documents probably aren't accessible for us to view, are they? Like the jury instructions that they're actually going over? Because I'm sitting here and I'm trying to actually look it up, but I don't imagine something like that would be accessible for us to read. But let me know in the comment section if it is. Like, I don't know if I'm looking it up the right way. I just Googled jury instructions Daryl Brooks. Yeah, let me know in the comments if that's even something we can look at. I mean, I'm almost like 98% sure that we wouldn't be able to see something like that, but it would be interesting to read it.
the motive instruction was incorporated on page 5 of 107. And I know that intent is an element of the battery. I don't believe that was incorporated. I mean, usually it's a standalone instruction. I think the court incorporated it with the first degree intentional homicide because certainly that was...
I think that's part of the pattern instruction.
Oh, it is. Okay, then we would ask for motive. I think that there's a 175 instruction that could be given as a standalone.
I'll look at that. Okay, we'll add that.
And then on page 65 of 107, which is the 70, the preliminary instruction, defendant proceeding pro se, there's the standard paragraph, which is the first paragraph listed under this instruction, and then there's an additional paragraph. We are going to object to that additional paragraph. I think it highlights the defendant's bad behavior. So I'd ask that that be taken out.
Another situation where they're kind of having his back here, like they're trying to keep certain things from being highlighted to the jury to help him.
Right, I made a note
He
of
never
that.
acknowledged that.
Okay, with regard to page 106 of 107. I believe that those were add-ons at the end that the court wanted to question the parties about.
Yes.
I believe that there was 325 should be given. One of the witnesses for the state did testify. He did have one prior conviction. I believe a witness for the defendant testified that he had a number of convictions. With regard to that same page 106 of 107, instruction 141, where identification of defendant is an issue, I don't know if it is an issue. That wasn't raised during the defendant's closing arguments. His opening arguments. I would know that, or note that the defendant would sometimes cross-examine people on if they were able to see the person driving or the description of the person driving, and he would cross-examine them as to their ability to perceive that. So I guess that would really be up to the defendant if he wishes that to be given. On page 107 of 107, instruction 172, circumstantial evidence, flight, escape, concealment, the state that was included in the initial instruction that we requested, and I would continue to request that instruction be included.
It's really just flight, though.
Correct.
What's that number again?
172.
Yeah, I know, it's just not there. I saw it, it's fine. But only as to flight. I made a correction on it, just gotta find it.
And I would say concealment to some extent, because he took off some clothes that would have identified him. But again, his running away, his trying to conceal his identity by removing some clothing that was identified by many
Right.
numerous witnesses as him wearing a hoodie or a light colored top.
Those were all, and do you have any requests as it relates to instructions that are not in the packet that should be?
No, Your Honor.
All right, let me turn to Mr. Brooks just to get whether he has his list.
Here we
not
go.
asking for a response yet, Mr. Brooks. What I'm asking you for is whether you have any requests for jury instructions, or if in your review you think anything needs to be changed, deleted, added, etc. I know I'd ask that it be put in writing, but I'll also give you this opportunity to verbally advise the court and make your requests. Do you have any requests as it relates to the jury instructions?
Oh, boy.
Sir? I would note he put 2 boxes right in front of where he's seated, so I can't presently see his face. I see his jacket is off because I can see the outline of his arms, and I can see the jacket on the back of his chair. He is unmuted. I've confirmed previously regarding the audio working, and I will just ask him a second time, sir, do you have any requests as relates to the draft packet of jury instructions, whether that be any additions, corrections, edits, or deletions?
And Your Honor, would it be possible for the bailiffs to just move the boxes off the table so
Yes,
we
I
can
think
see?
that's fair. I'm going to advise the bailiff
Oh,
to
no.
remove the box so I can see
No.
Mr. Brooks.
That's definitely a tantrum.
I don't know what he's doing.
He can't hide anymore. All you hear is a sigh, though, coming from, I think that
He has quieted down.
he screamed himself out like he's worn out from screaming.
If you could move the second one because it can interfere with the microphone as well. And the third one.
I should have got a thumbnail for that.
Mr. Brooks, I'm going to ask you for a third time. Do you have any requests as it relates to the jury instructions? Any requests for instructions that aren't included that you believe should be included? Any edits or deletions from the packet that has been provided to you?
Hey, why do you tell them to move my box?
Because I couldn't see you, sir.
Or what?
I've asked you twice now, and I'll ask you a third time. Do you have any requests as it relates to the jury instructions? Any additions, deletions, edits, or otherwise?
Hey man, you don't gotta talk to me like that.
Do you have any requests
First of all,
related
what?
to the jury instructions, sir?
Man, yeah, I got requests. It ain't like they gonna be honored though. Cause
As it
nothing
relates
I've
to
been
the
trying
jury
to get done
instructions,
is-
sir, what are your...
I heard what the hell you said, man.
Well, Mr.
Can
Brooks,
we
that
mute
was
him?
very
That would have been a
disrespectful.
perfect time.
Yeah, and I've been getting disrespected since the beginning of this whole process. So welcome to the club.
Mr. Brooks, do you have any
I'm
requests?
tired of my race being trampled on here too. I'm tired of it too.
Do you have any requests as it relates to the jury instructions?
Ain't nobody understand why I'm frustrated.
No one cares what you're frustrated.
And make decisions based on what you think I said when I didn't give consent for you to do any such thing.
Sir, I understand you may be upset, and I really do, but I've made my determinations.
You don't understand nothing. You don't understand anything, Your Honor. You don't.
I'm going to mute him again because he's not answering the questions that I'm very clearly asking him, and I've given him
The mass
5
murder is sad,
opportunities.
isn't that?
Mr. Brooks, do you
That is
have
ridiculous.
any requests as it relates to the jury instructions? I'll unmute you for that answer.
I can't hear everything you're saying.
I don't even know what he said right there.
Mr. Brooks, I know the audio's turned up. I believe you can hear me. You've chosen not to put the headphones on. That's your choice. My final question to you, do you have any requests as it relates to the jury instructions?
I just told you, am I muted? Am I muted?
No.
I just told you, I don't know how many times, I can't hear everything you said.
Then you should put the
talking right
headphones
now.
on.
What about those don't understand? If you see headphones, you can see everything. You can see boxes, but then you see headphones.
Have you asked for headphones to be provided, sir?
I shouldn't have to ask him. I didn't ask for my boxes to be moved.
I believe they took them away previously because you were so agitated they were perhaps afraid you might break
Yeah,
them.
I'm still agitated. I ain't gonna stop being agitated. That ain't gonna stop.
I have no idea why Judge Darrell is still entertained in this. At this point, like, he's screaming at her and she has the ability to put him away for the rest of his life, which she's going to. She's gonna do that. I wish right now that she would just mute him and we move on. Like this type of thing right here where he's just like screaming at the top of his lungs. He feels like he can just have his way. Like he doesn't care at all how he looks, how he's treating people. He's just doing literally whatever he wants in the moment. Like he's such an unpredictable person. Like you can see when they're not giving him any attention, he starts looking around and he's thinking about what crazy thing he can do now, given what resources he has around him. This is why I call him an opportunist, by the way, because you can see like that weird, like almost predatory way that he looks around for an opportunity for something, and then he saw the boxes. Oh, okay, now I got these are tools I can use, and he blocks himself from being viewed like that's a punishment to us or something. But once again, because I see people talk about this in the comment section, it's like she has to cross every T, dot every I. So, and of course he's representing himself right now, so it's like she has to, in a way, she has to allow him the opportunity to say things. But in moments like these where he's clearly not trying to say anything, he only is using it as a stage pretty much for his clown show. I just wish you would mute him and then we move on, but yeah.
You sit up here and do everything you're doing and think God don't see what you're doing?
That is, wow.
Mr. Brooks, do you have any requests as it relates to the jury instructions?
I can hear what
The
you're
mass
saying.
murderer.
I can hear what you're saying.
You just told me you didn't. So which one is
Yeah,
it?
I can hear about something. Don't see that?
What are your requests as it relates? What are your requests as it relates to the jury instructions, sir?
Man, don't try to come with this whole little image, sir. Now it's all this sir and all this. I'm gonna get where I'm going. Try to put
What?
on this little act like you so worried about what's going on with me. You don't give a damn. Never did.
Mr. Brooks, you're being disrespectful
It's
again.
true.
You've been being disrespectful. You've been being disrespectful.
I need to know what your position is regarding the jury instructions. And I need to know it now.
What you mean? Who you talking to?
I'm talking to you. I
What?
need to know whether you have any requests as it relates to the jury instructions, sir.
Yeah, first of all, why am I charged with 2 bail jumpings when I was already charged in Milwaukee for the same bail jumping? That's double jeopardy.
That's not double jeopardy. Your objection is
It
noted.
double
It's
jeopardy.
overruled.
It is double jeopardy. How you gonna charge me with the same charge that I'm already charged with? You can't do that. The Fifth Amendment says that you can't play.
Oh boy. Legal advice from Daryl. Let's go.
Twice. I'm already charged with the same count in Milwaukee. For the same case. It's the same bail jumping charge. So how am I
Okay.
charged with that here?
Sir, I'm not going to provide a legal explanation other than to say I've reviewed that. Your objection is noted. But the jury will be instructed regarding the bail jumping.
It can't be, because that's double jeopardy. Under the law, if two charges are identical in nature, you cannot place me in jeopardy of life and limb twice. You can't do that.
What's your next?
The same case number.
What's your next request, sir? I'm noting your objection.
I'm trying to talk. Can I get it out? You always want me to not interrupt you, but you always find a way to talk over me.
She's the judge, but okay.
I understand your position. I'm saying it's overruled.
You always want respect. You always want respect, but don't want to give it. I'm charged with the same bail jumping charge here that I've already been charged with. That is double jeopardy. You can't charge me for the same exact bail jumping that I'm already charged with, that I was charged with before this even came about.
Sir, the bail jumping charges in Waukesha County are based upon your violating your bail while in Waukesha County by driving through the Christmas parade and allegedly killing 6 people and injuring 61 others.
Okay.
That's the distinction.
Again, there is no distinction. It's the same charge.
It's the same offense. It doesn't mean it's the same factual basis, sir.
He is not
It
charged
is.
with bail jumping with the data violation of November 21 in Milwaukee County anywhere. Further, the double jeopardy prohibition would prevent him from being convicted twice, not charged twice.
All right, so we've addressed that, sir. What other requests do you have as it relates to the jury instructions?
I want to know why I'm even charged twice with the same thing. You can't charge me in pursuant to a case in Milwaukee.
Okay, sorry, I'm pausing that, but this is a perfect example. Like I said, an opportunity. He just goes right to the next thing. They just explained it to him, right? Now he stays on the topic. He did do that, but now he just moves on to like a whole different variation of it. Well, why did I get it in the first place? It's okay. All right.
That I'm already charged with bail jumping for. I'm already charged with bail jumping for that already. So you can't essentially say, oh, well, because you were already on bail, we're going to charge you.
It's a different data violation, sir. The conduct for the bail jumping is related to the allegation that you committed a new crime in Waukesha County while out on bond from the Milwaukee County case.
Yeah, but I'm referring to the first bail jumping count. The first. I'm not referring to both of them. I'm referring to one of them.
My understanding, sir, is there's different dates of violations as it relates to that. So I've noted your objection now repeatedly. I understand it. Your request to, I guess, dismiss the bail jumping counts are denied.
I didn't say nothing about counts. I said one.
Whether it's one count or both, it's denied.
Am I not being understood? You can't charge me with the same charge twice. You can't.
It's two separate cases, sir. There's two.
Isn't that 971.23?
Daryl, use your last remaining brain cells. Understand.
Sir, I'm not going to have an argument. This isn't fruitful. I understand what you're saying. You're saying there shouldn't be 2 counts of bail jumping. You believe it's double jeopardy. I disagree with that. They're separate.
I'm already charged with it, though.
This is a circular argument, sir. It doesn't change the fact that, from my perspective, the 2 bail jumping counts are going to proceed forward. There's been sufficient evidence presented to warrant the jury being instructed.
They can't.
What other requests do you have,
You're not
sir?
going to talk over me. Don't talk over me. Just like you don't want me to talk over you.
Please keep talking. Talk over him right now as we speak.
Mr. Brooks, what
There you
other
go.
requests do you have?
And I just asked you not to talk over me.
Do it again, please.
You've been making your record the whole time you've been over there. You had me muted. I didn't see no requests over there. I didn't write nothing to go over there. I let you do what you was doing. No matter how egregious and biased it is, I'll let you do what you was doing. Because we both.
You know, okay, sorry to pause in the middle of that. Sorry to pause in the middle of that. But it's like at this point, it's like it was shocking at first. I feel like I'm saying the same things at this point. But it's like this isn't even shocking anymore that he's doing this bit, like that he's all of this, like, don't scream over me. And he's talking to a judge and he's telling her to not talk over him, as if he's the one that's in the judge's seat and she's on trial for driving through a parade. But it's so weird. Like now, I feel like that moment where Judge Darrell was just staring. Like I feel like she kind of feels the same way. Like, this is so stupid. This guy, he has nothing left. This is really it right now. This is his last like moment to feel as if he has some sort of power, the most powerless individual ever, and this is what he's doing. Really, I'm just hoping that Judge Darrell speaks over him. As soon as he gets like near the end of this little rant here, she just talks over him and just keeps talking and then mutes him and then continues talking as if it doesn't even faze her. Like, I don't know.
You know that what you're doing is not right.
Mr. Brooks, I'm going to refocus your attention to the jury instructions. All of your objections are noted. I understand that. If you can't answer my question, I'm going to move on.
You can't. I haven't given you consent.
She definitely
I'm going to
can.
mute him once again. He refuses to answer simple questions regarding if he has any requests. He just made an argument regarding the bail jumping, so clearly
I'm so happy she did
has an
that.
understanding about the law as it relates to that. It may be a misunderstanding about the law and double jeopardy, but he made an argument. I've denied it. I'd like to know if he has any other requests. If he can stay on topic, I'll I will unmute him again, and he can tell me the list, just like the state went through a list. I need to get through their list. I'm asking you to list out all your requests, and then I will take each one up in turn. So here is your opportunity to give me your other requests.
Please do not do this. Of course she's going to do it.
Go ahead, Mr. Brooks.
Don't sit up here and try to play no game talking about you giving somebody an opportunity, because you haven't gave me an opportunity to properly defend myself and put evidence, put stuff into evidence, which I've asked you repeatedly to do before we even got to the trial. You told me we wasn't in the evidentiary phase.
Mr. Brooks, do you have any other requests as it relates to the jury instructions? This is probably the 10th or so time I've asked you this question.
No, it's not. No, it's not. So please stop being incorrect, Your Honor. Please stop.
Do you have any additional requests as it relates to the jury instructions?
Yes.
Oh.
That first count 74 bill jumping needs to be dismissed. You can't charge me with two things. You can't charge me with the same charge twice.
Okay, so that's
All right,
it.
I made a note of that.
That's the only thing.
What's the next issue?
Either one company gonna charge me with it or y'all, but it can't be both. It's the same. It's pursuant to the same exact thing that I was on bill for. The same exact thing. The same exact case. So why are we giving the jury instructions on two cases from another county?
I've made a note of that. What other requests do you have?
Man, this is ridiculous. So I'm not even able to adequately defend myself, present evidence, do anything, because everything I say is going to be found a reason for it not to be valid.
It's not like she's giving him the opportunity right now, right?
Mr. Brooks.
And he's screaming instead.
Why should I be here when
I've made a note of your request as to count 74. Do you have any other requests as it relates to the jury instructions?
Why are we even having jury instructions? Why do I have to be
There it is.
in the courtroom at this point? Because everything you've been doing without my consent anyway. So you're gonna find a way to do this without my consent. So why do I need to be here for?
Your objection for lack of consent is noted for the record.
Okay, yeah.
Any other requests, sir?
You talk a good game. You talk a good game to save yourself enough space. But everything I put together, it has no merit in your court. None.
All right, I've asked him many times. I've advised him, and I'll advise him once again. If he fails to answer the question, I'm moving on. Do you have any other requests?
Oh my goodness, there's no more advising needed. It's over.
Because I haven't given you consent to.
All right, he did not answer. So I'm muting him again. The only request that
Nice.
he has made as it relates to the jury instructions, as he pounded his fists once again, raised his voice. I understand, I really do, that he's upset with my decision to cut off his ability to present a defense, but that decision was made based on his conduct and his conduct alone, as I've outlined already on the record. So the only request that he made was as it relates to the bail jumping counts. I'm denying those requests, whether it be to dismiss one count or to dismiss both on double jeopardy, or to just not instruct the jury. However way I interpret it, I'm denying that. All right, let me go through the state's. Sure.
I'm sorry.
It's to the point now.
154
Hold on.
summary of evidence. I believe we had a map, actually 2 maps that summarize the, we had 3 maps, I think. The one was summarized his route, the path that he took. The other one summarized the victims who were struck in the specific locations. And the other one summarized the positions of the law enforcement officers at the various intersections and throughout the parade route.
I'll make a note of that. I don't believe I saw the jury view instruction either. I mean, that was given to them at the time. I don't know that it needs to be reread, but I think we need to consider that as well. And that was my version of 152.
152.
All right, so let me go through.
I mean, it's no need for me to pull it up. They just described what it is.
From the state.
What is he doing?
Turning to
There you go. He's
61.
the Ford is back in action. it's back.
So I've considered
In
the
full
request
effect.
by the state. I am going to rely on what information they put in the charging document. I'm going to deny the request to include the specific case numbers. There's evidence, of course, that was received regarding the 2 separate cases out of Milwaukee County that form the basis for both of the bail jumping counts. It will be up to the jury to review the evidence and make a determination. As to the verdict forms, though, that were referenced previously, at least the description of them in the jury instructions, that obviously the 3rd count of bail jumping is incorrect. That needs to be battery, and that change will be made. I'm also having Madam Clerk include all of the numbers for the jury instructions when they go back, so it's very clear. Some of them did not have them on, just frankly from prior cases that she and I have worked on, but in this case I want to be very clear with all of the numbers. So I think I've addressed the first 2 bullet points. As far as the motive instruction as a standalone, I believe that is appropriate, and I'll instruct Madam Clerk to include that. As far as where it goes, I'm going to just, any instructions that we add should just be in the numerical order, unless there's a other request that's made. Then the state also made a request as it relates to jury instruction 70, which is found on page 65. So as it relates to this, the state is asking that I simply instruct the jury based on the pattern instruction and not include that second paragraph. I had previously advised the jury with another paragraph that I was contemplating including, even if I took out that big paragraph that just said, at times Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any manner. What's the state's position on including that, but taking out the paragraph you request to be taken out?
That's fine.
Mr. Brooks, do you have any position on?
Okay, before he speaks, I know for a fact he's going to try to say, oh, this proves bias. You're going to put that in the document? Like, he's going to say something about how this proves that they're biased and they planned on putting him in the other courtroom. He might not do it because he might still be stuck on the previous topic that he was arguing about. But I just have a feeling, and this is what makes it, like, it sucks that he's representing himself, because she could just throw him in the other courtroom and mute him and keep him muted. But since he's representing himself, she has to make sure he's informed, and that she has to know if he has any objections to, like, certain parts of documents. And that's what makes it so much more frustrating, because if he didn't represent himself, she didn't have to cut him so much slack with this stuff. But okay, talking because I know exactly I know what's about to happen, but I'm not going to keep it muted.
Which is so jury instruction 70 has to do with the defendant proceeding.
I'm not going to keep it paused. I mean,
the pattern
I'm so used
instruction
to
would be basically the first
her saying
paragraph. I need the bailiffs to move the boxes away from his face. I need to be able to see him. He can keep them on the table, but they need to be moved off to the side. And if he does it one more time, then I will instruct the bailiffs to take the boxes away. Those are trial prep materials. If there's
He's
something
gonna
in
get
those
so
materials
mad.
related to jury instructions, he should take those out now. Otherwise, they need to be
Here we go.
moved away from the microphones and away from blocking his face.
I'm not putting them there. I'm not putting them there because you can't see me. I'm putting them there for a reason. I'm not letting do with her being able to see.
Mr. Brooks, do you have any position on the verbiage of jury instruction
Don't ask me-
70
don't
on
ask me
page
no question.
65?
Don't ask me no question. Are you my accuser? Are you my accuser, Your Honor?
All right, he's choosing not to answer, so I'll mute him again. It's unfortunate that he's deciding not to participate in
She's
this.
not letting.
I agree with the
Sorry.
state. I don't need to highlight.
I know I keep pausing. It's little comments I keep wanting to make. She's not letting him do whatever he wants. So he's very angry about that, which is so childish. This man is a grandfather. You know, of course he's not in their lives, so I'm sure he doesn't think of himself in that way. This is so weird. Okay. All right. Okay.
That second paragraph, I will take that out, but I will include in the paragraph that reads, at times, comma, Mr. Brooks has appeared from another courtroom, period. This must not influence your verdict in any manner. Inclusion of the instructions that were put on the last couple of pages include 325 impeachment of witness. Its prior conviction, the part about juvenile adjudication, should be struck from the heading. And it should read, evidence has been received that one or more witness in this trial has been convicted of a crime. There were 2 witnesses that was applicable to. The remainder will be as is. And that was 1 witness for the state, 1 witness for the defense. I just will add that if Mr. Brooks has any position about these requests, he should, he is currently muted. He can raise his hand and I'll unmute. Otherwise, he can pass a note to the bailiff or simply tell the bailiff, who can then tell me and I can unmute him. But unless he tells me, then I'm going to assume he's made a decision not to provide further comment based upon the last statement he made.
Nice. Yeah.
Then 141, I believe that's appropriate given the evidence that has been received. That's on identification of defendant is in issue. That I will instruct the jury accordingly unless there's a request from Mr. Brooks to take that out. Is there a request from you, sir, to take 141 out? I'll unmute for that purpose. It's found on page 106 because it's at the end of the instructions. This is the instruction on identification of the defendant and where it's at issue in a case. I believe it's appropriate given the testimony in this case. Do you have any position on that, sir? You are unmuted, so you can simply answer yes or no. No response. Then 172, circumstantial evidence, flight.
He made it so easy.
Concealment, I believe, is appropriate given the evidence that has been received during this case. Yes, sir?
Am I unmuted?
You have been.
Am I unmuted?
You are.
So how long before you mute? As soon as I say something?
Depends on what you say, how you say it, and if it's responsive to what we're doing.
Why do I have to be responsive to what you guys are doing? Nothing I say even matters at this point. So what's the point of me being responsive? You can't make decisions for me.
Mr. Brooks, I'm going to mute you unless you can participate in what we're doing, which is discussing the jury instructions.
I'm gonna tell the jury the truth. That's what I'm gonna do. I'm gonna tell them what hasn't been told to me. I haven't been able to.
Mr. Brooks, I'm going to mute you because we're trying to discuss the jury instructions, not what you're going to say during your closing argument. I will get to that later. In terms of instruction 172, I'll instruct Madam Clerk to take out of the heading the word escape. Should just say flight concealment. And then I've reviewed 154. I believe that's appropriate. I'm going to pull it up just as a draft. I'm not sure if there's anything that needs to be. So the pattern instruction talks about a chart. Is there any request from the state as to just keep that or modify that in any way based upon the evidence that was presented? Because you actually submitted maps and things were received. I don't know that summary.
I think that there was a summary of the victims and the associated counts. I believe that that was exhibit 141.
But that was received, wasn't it?
And there were some charts of the extreme dance team, the formation, and dancing
Right.
grannies.
Let me see if I can actually pull this up. 141.
Do you have a?
So I can actually kind of follow along. So I think this is going to be a pretty slow-paced day.
What are those numbers again? I wrote 141.
We're just looking for the extreme dance and dancing granny charts.
And of course I don't have it.
Grannies is 54. 54 would be the dancing grannies,
Okay.
and 33 is extreme. And 33 is the extreme dance team.
So 54, 141, and 33.
Yes.
Do you think the use of the word chart is correct, or should that be?
I would say diagram and maps. The court has allowed the use of diagrams and maps to organize the evidence.
The maps were evidence, though. What this instruction says is the court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was permitted or presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence.
Then we think 154 should not be given
That's what I was wondering.
because
So
they were all admitted.
They were all admitted based upon how they were presented and the
I apologize.
testimony regarding them. Typically, where that comes in is for use in openings and closings solely that are based upon evidence, and we anticipate those things coming in, not when there's been an actual document that's been admitted. So I don't think 154 is needed, and I'll deny that request. What about 152 regarding the view?
Your Honor, as I read that, that was given prior to the view, and I think that was appropriately given at that time. I don't believe it goes into the closing or the final instructions.
That
would be
was
my position.
my inclination, but I wanted to get the party's position on that. I'll once again unmute Mr. Brooks and just ask him if he has any position regarding any of these last issues that we've discussed with, as it relates to the jury instructions. Anything from you, sir, on the jury instructions?
I think I see what he's doing now with this as well.
He's not responding to the question.
So he's doing this thing where he's pretending as if it's like a delay or something. So he'll come back in like 30 seconds and he'll pretend as if now he can hear what she's saying. I guess maybe that's what his angle is right now. He's pretending as if it's some sort of delay with the audio, which, okay, it's random. I guess that's all he can do.
That covers all of the issues that were raised by the parties then. You are. I'll give you one
Okay,
final opportunity
that is what he's doing.
to tell me if you have any requests as it relates to the jury instructions, sir.
What you mean you giving me one final thing? I didn't consent to nothing that y'all been talking about. And I say y'all because I haven't been participating in none of that.
I understand, sir. Your objection's noted. Your lack of consent is noted.
Okay, I don't see what's going on in there. So how's decisions being made without me being able to consent to it?
Sir, you forfeited your right to be present in this courtroom by your conduct, and you have not requested to come back.
Actually, you took a break. So let's make sure the record is correct. You took a 10-minute break.
I did.
At which time I was brought back into this courtroom.
I was advised you wanted to stay, sir.
Okay, and you've been forcing me to come over here from the get-go. Why couldn't you force me to come back over there where I'm supposed to be at?
Sir, my understanding is you requested to stay in the other courtroom. I thought I put that on the record at the beginning. If I did not, I'll make that part of the record now. I was advised by the bailiffs that you were requesting to stay in that courtroom. I certainly advised you prior to that if there was a time you wanted to come back in, all you needed to do was ask. You've done that previously.
Yeah, but
and even during this time, though, you've been incredibly disruptive.
I can't say that.
At one point you were muted for an extended period of time and you were yelling so loud, sir, we could hear you in this courtroom. I couldn't decipher what you were saying, and I was also made aware that another branch could hear you. So you continued your disruptive behavior.
That's fine, because at the end of the day, I should be heard. I have the First Amendment right to be heard. So if I'm going to be constantly muted, the only way for me to be heard is for me to raise my voice.
Okay, this is a bit of a weird question, but does anyone know, like, I'm sure all trials all trials aren't public, but is there any footage or something of a separate trial that's taking place and you can hear Daryl screaming in that footage or in the audio of that? If anybody knows, because there are a lot of people in the comments section, you all know so much more about the ins and outs of this trial. There are so many even small details that I never knew, I didn't realize, that everybody lets me know in the comments. So if anybody knows about something like that, which I feel like it's probably not a thing, there probably isn't any audio or footage of another trial or something, and you can hear Daryl echoing in the background, but I'm gonna ask just in case. Let me know if there is.
Mr. Brooks, one final time, do you have any requests as it relates to the jury instructions? Otherwise, I'm going to approve them. I'm going to take a break, and then we'll come back in the afternoon to go over verdict forms.
I didn't answer yes or no, so how do you consent to anything without me answering the question?
Are you going to answer the question, sir?
You can't force me to do it, though. You can't just say, I'm going to do this.
This is
Sir,
so
but
ridiculous.
You also can't stall the proceedings by failing to answer.
I didn't try to stall the proceedings. You the one that held me in contempt.
I never held you in contempt. All right, I'm going to mute him once again because he refuses to answer a very simple question about whether he has any requests as it relates to the jury instructions. I will work on making all the changes with Madam Clerk, finalizing the order, print them off again. She has been working on the verdict forms, which are of course separate, which need to be approved by this court. So those will be printed off. A set will be provided to the state, a set will be provided to Mr. Brooks. We'll take I'll do a 90-minute lunch break, so it's 11:27.
Wow.
So we'll come back at 1 o'clock to finalize the verdicts and the jury instructions.
And Your Honor, with regard to sequestration of the jurors and the alternates and those issues, did you want to address those this afternoon?
Yes,
Okay,
we can do that.
thank you.
I can put on the record that I had the civilian jury bailiffs provide the parties. We have a letter regarding sequestration. There's an emergency contact form. So all of the jurors were made aware of that. They know that. Of course, once the case is, all of the instructions are read and the parties make their arguments, and then there's some final instructions at the end, and the case goes to the jury. Obviously, only 12 of the 15 will be deliberating, but we can make a more full record of that this afternoon.
Thank you.
All right, we are in recess until 1 o'clock. I'm just instructing the parties to stay until the handout of the verdict, and then you can leave for lunch. Thank you.
All right. You know something, I can't unsee this now. His hairline, like a lot of people said this in the comments, his hairline makes it look as if he has devil horns. And the whole time where it's like the screen was cut off to where you can only see his forehead, or not the screen was cut off, but like he was hiding behind the monitor, which is creepy. It really stands out when he does that. Yeah, I don't know. He's a very creepy person. Hope you all enjoyed the video. If you did, please like, share, and subscribe. Hope you did something good for somebody today. Hope somebody did something good for you, and I'll catch you all in the next one. Peace.